A very good day, everyone. This is Ankita Arora from STUDYMADEEASY. So, as I told you, there were some reasons due to which we were unable to do the live classes today morning. So now I'm providing you the recorded class for second part of appeal and revision IDT. Most probably for DT, today we will not be able to cope up that. Okay. So I'm starting right now with your IDT part, and IDT ka part number 2. What was the chapter? It was appeal and revision. Now appeal and revision mein what we have studied, that what is appeal and when appeal is done and when revision is done. Okay, that we have little bit done. That if you want to appeal, first of all the order or decision should be passed by an adjudicating authority. Adjudicating authority का decision and you are aggrieved by the decision of adjudicating authority, you will apply to appellate authority. After getting application done to appellate authority, if you still find that you are aggrieved by the order of appellate authority, you will go to appellate tribunal, then high court, and then Supreme Court you have to go. This is the scenario, this is the sequence that we have already done in appeals and revision. Now, till first part, that was adjudicating authority, we have just studied some terminology. What is review? We have studied what is refer back, what is revision, what is reopening. We have done all this thing, and what is revive. So कुछ चीजें हमने करी हैं. मैं for the time being I'm not going into the revision, just have made you recall कि कितना हमने उसको क्या किया, what we have covered. For today's class my video would be off. ठीक है, so I'm continuing the class without video, so just pay attention on the mind map I'm showing you on the screen, and उसके बाद हम लोग साथ साथ में वैसे याद करते जाएंगे, and after learning you have to write it down. Okay, चलो. So till now we have done, till now what we have done, Whatever direction they feel, they can just give that direction that is just sufficient for that ground. Then what about, ma'am, additional evidence? Yes, additional evidence can also be considered. Suppose same evidence are again presented. Now this person called an appellate authority to submit a new evidence. Then appellate authority, I'm not, I'm talking about appellate authority. Can appellate authority admit a new evidence? So the answer is no. Appellate authority cannot admit new evidence. However, the appellate tribunal has power to admit the new evidence. Natural justice, yes. How much adjournment is possible? So adjournment up to 3 is possible. And what is the advisory time to complete all these things? It is nothing but 1 year. So in case if the authority has evidences, obviously only appellate tribunal can accept the new evidences. Adjudicating authority cannot admit new evidences. Then your appellate authority cannot, tribunal can. Advisory time limit, matlab it is just an advice. You should 1 year and 1 year. Is there any rectification of error possible? Yes, rectification of error if appellate tribunal has passed any order. Is it possible that if appellate tribunal has passed any order, rectification could be done? Yes, rectification is possible either by own or notice brought by central government, notice brought by GST commissioner within 3 months from the date of order. Remember this time, from the date of order. Within 3 months from date of order. So either error could be rectified by someone within 3 months from the date of order brings to your notice that there is a mistake, there is an error in your order, or no power of review. Now you know कि review का power is only to High Court only in case then natural justice is not followed. In last class we have already discussed this thing. Okay. So यहाँ पे rectification of error में what you should remember this time limit, and you should remember that review power has not been given, only rectification of error power given, and rectification is mistake apparent from record. Mistake apparent from record. Now, when I talk about tribunal, it is something you that is memorandum of prosecution 45 days, 45 days. We have learned that up to 1,000 they will refuse to admit that. We have also seen that refer back is possible. We have seen additional evidence possible. We have seen adjournment. We have seen rectification. Now, what are the topics or pointers in our appellate tribunal? Now you should also understand what are the key pointers. This memorandum of prosecution. Key pointer is tribunal authority decision. It could provide key pointer when it could refuse, key pointer refer back, key pointer additional evidence, key pointer 3 and then your star adjustment, that is rectification of error. One more thing is about constitution of tribunal. Now, about constitution of appellate tribunal. When it comes to the constitution of appellate tribunal, there is two-tier bench. Two-tier bench means national level bench as well as state level bench. So as well as national level, and each of the regional level, it is also on the basis of area. Means on the basis of region, on the basis of area, all the benches have been divided. When it comes to national and state, when it comes to national level, only 2 members are there. When it comes to state level, regional level, area level, there are 3 members. It is just a one-time reading. One-time reading, but yes, you should remember these members. That there are 2 members, national level, and all the levels, there are 3 members. Who are these members? A judicial member, a technical member at state level, a technical member of the central level. Now, when it comes to national bench can solve place of very advanced ruling. That is the reason, as it is found on state basis, authority cannot solve the case of similarly. Your appellate tribunal of state level, regional level, area level cannot solve because now GST is destination based tax, and if state level will solve the place of supply, fight among them related to the revenue collection. So it is only my national bench that will solve the place of supply related decision. What if, ma'am, any one of supply directly move to Supreme Court? They will not go to High Court also. Why? Because High Court is also jurisdiction wise. Understood? And for rest of the cases, you can move directly to High Court. Understood? Now, second thing is, ma'am, you are saying that 2 members at national level, 3 members at other level. Is there anything possible when only single member in a bench can solve a case. Yes, a single member can also solve a case, and for the single member, how it is possible? Absence of member. See, first of all, here absence of member. Valid reason. It could not be considered that absence of a person is there. It could not be considered proper judgment is not given. And in fact, a member of two bench, it can be heard by the bench of two members. See, generally when it comes to state level, generally when it comes to national level, when it comes to state level, when national level or regional level, there are three members. Now they are saying due to the absence of any member due to reason, is it possible that only two-person can solve the case? In fact, a single bench member can also solve the case, but permission of president at center level and state at state level is needed. What is the case? Solve the case when ITC takes the difference, penalty or fees. It does not exceed 5 lakh. When ITC tax penalty does not exceed 5 lakh and question of law is not there. There is no question of law, because whenever there is question of law, you have to go to High Court, Supreme Court, and in High Court, Supreme Court, you have to compulsory move. And where it is about, where it is about to 5 lakh case, I will not question law of law case even, and members can also see. I think it is more than 5 lakhs. Question of fact. Still single member can not. And case is equal to 5 lakhs. And this question of law. Still single member cannot solve that. And case is only of 1 lakh. And question of law. Still single bench cannot solve because it is an it is what and condition. Understood? So what we have done in appellate, then memorandum of process we have done. When it can refuse, refer back we have done. 3 times adjournment we have done. Additional evidences we have done. Rectification we have done. Constitution. Just because of the issue that I'm running right now out of some of my resources, I'm not revising this again and again. I'm just explaining you one time. When we will be back with our classes, I will again revise these things for you. Okay. Now, when it comes to appellate authority, now you are aggrieved by the decision of appellate authority. You will directly move to High Court. You will move there to the High Court. When you want to move to High Court, in such a case, you cannot go for the question of place of supply. You cannot go for the question of what? Place of supply. That means other than place of supply, you can go to High Court for any question of law. And date when order appealed is received by the person aggrieved. Date when order appealed is received by the person aggrieved. The time limit is 180 days. Within 180 days, received. It is not date of communication. It is when the order is received by the come on this. Suppose High Court has given order on 1st of July. Okay. However, the written form of the order was typed on 5th July. However, the order was dispatched on 8th July and the order was received on 10th of July. In such case, the one come from 10th July, it will not come from here, or here. Because it is from the date of receipt of order, you have to count 180 days. Now, when it comes to order, to High Court, it should be what? Question of law. Yeah. Now, what is the decision? Decision is based on majority. And ma'am, if there is difference, when it comes to High Court, all the decisions are done properly. But if there is difference of opinion in such a case, majority will decide the decision of the High Court. Ma'am, what are the decisions of the judgment? The judgment of the High Court additional could be possible if High Court is satisfied that the case involves the remember one thing I have already. When you apply now, person do not have the right to add different questions. It will be entirely on the new questions or not. Remember in last class I have told is certified by High Court wala point. In such case, when it is certified by remember one thing, definitely you have to remember that additional question could not be added by the person. It would be entirely on the discretion of High Court whether they want to satisfy and whether they want to, and they will only and only if they are satisfied this case involves such a question. Okay. Now again, if you are Supreme Court, in such a case, move to Supreme Court, and you can move directly to Supreme Court when it is place of supply related question. And then Supreme Court revised the order of High Court. So my overall to appellate to High Court to Supreme Court gets completed. Now we have studied that elect women can if some person is person agrees that revision authority can apply to elect women. So what is that revision authority? Revision authority revise the order. Then it is some around that is if the order should have been taken by the decision that in such a case, revision authority can revise orders by state authority and state authority. Why not? Because that passes when you revise women. That is revision authority is only to elect women. And see, revision authority revise as it is said by the order. Now, it all the thought present, all the and the basis of all that means what is the case for there are two evidences. Now, at the authority is there are five evidences. All the all the records it is I think no then is ये whatever High Court ये लोग रिवाइज कर सकते हैं because they are senior to revision persons. This two. Now, when it no revision at all, revision हो ही नहीं सकता, no power of revision at all, no power of revision. So, the case number one, already order subject matter of already
revised. When period of 6 months has not elapsed, just now ordered something, just now ordered something, and 6 months has not elapsed. What is the reason of this 6 months? The reason of to appeal. So if department can appeal in 6 months, to wait for 6 months has not elapsed, so no revision is possible. And after the order, 3 years already elapsed. We order already sense. What is the sense of revising order after 3 years? Then already it is in revised order. Already earlier stage means order has already been revised. So it is already a revised order in such a time. This cannot be revised. Appeal pending, no revision possible. 6 months not elapsed, revision not possible. 3 years already elapsed, revision not possible. Revision revised order. It is not possible. Right? Okay. Now this is something as a homework to explain me what is the language of all these things. You should read this from first study material, and in my next class you have to tell me the meaning of this language. So all of you just mark of this language. I am unable to understand. I don't know what is the meaning of this. Always in my class, the task to just read the language from the material is fun. So this I have done. And no, what are cases that appeal is possible? No appeal is possible. My officer has suspended. My officer got suspended. My officer died. My officer got transferred. So my another proper officer. So is this the case of appeal? Transfer of officer. It is not transfer of appeal. Then when order is your good, you can books of account your documents books of account documents that seized. It's not goods being seized. It is books of account documents. You cannot apply. Already that means that you have done and regress that they have already initiated or they have already process not possible and when order you can submit your taxes in installment. So you cannot I want to pay 50,000 installment. But government is saying no. Instead of 50,000, you have to pay 80,000 installment. So you cannot pay. You cannot agree that I wanted to pay 3,000 installment. They have to pay 80,000 installment. So all this are matters of what are not Caesar of books of account? No. Pension of cannot appeal. Then change of your office section number 80, that is tax payment in installment is not matter of appeal. Now last and the last additional evidence. Who already whether it is applicable, generally applicable and applicable both cannot additional evidence. And we have just done this. The applicable and accepted, but applicable no, it cannot additional evidence. No, 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 no. But there are what are the evidence, however, this evidence was given by that person. With person evidence is given time by that person received that appellate authority or appellate appellate authority refuse कर दिया भाई, लोअर लेवल पे नए एविडेंसेस रखे गए थे, लोअर लेवल के सामने, इन फ्रंट ऑफ लोअर level, that is additional evidences were given, उनसे ये evidences already देख सकते हैं, refused to admit, तो आप split vehicles admit करके as इनको क्या कर सकते हैं, additional evidences दे सकते हैं। और appellant was prevented from, he wanted evidence but there was he was unable to give, or he has actually all the evidences. He was asked to give the evidence, but he was unable to give the evidence. He has given the evidence, but my authority has not even considered that evidence. या तो उसने दिया और consider नहीं हुआ, या फिर उससे मांगा. So if all these cases are there, if all these cases are there, then only additional evidence could be accepted. Otherwise, additional evidence could not be accepted. And while objections to application to others. So this complete answer that is appeal and revision. For time being, please think of this from we will again quickly next class. For the time being, we have and one more class is this wala part that is given you. Okay. So just for the time being, I'm closing the video right now. I hope समझ में आ गया. Appeal and revision. In the next class, we will be looking forward to the next wala topic, and most probably the topic will be or okay. So thank you.